is that the circumstance we find ourselves, or this decision of the Supreme Court is a travesty? Is it fidelity to the Constitution, or it is not? Stay right here. We'll break it down. I'm Samson Ladia Yenini, and I'm privileged to be hosting the morning show with Kojo Yankson, Winston Amwa, and Mama V. Owusu Abuaji.
I couldn't understand what all of this furore and controversy that was artificially generated. We're being told that the decision of the court amounts to judicial interference in the work of Parliament. I'm not quite sure that the people who are saying this have actually taken the time to read the Constitution of our country. It says so in black and white. The legislative power of Parliament that is vested, of the state which is vested in Parliament, is subject to executive. We are all subject to the teachings of the Constitution. There's no body in the Ghanaian state that is above the fundamental law of the land. It would lead to the very matter that we have striven so long to avoid. The concentration of power, of unregulated power in our state. We don't want that. We've had that experience before, and we brought about this constitution in order not to allow that to reoccur. In an area, on an issue where there is so much clarity, and I'm happy that the court, and I'm sure as you're aware, the Supreme Court, when it is declaring the meaning of the Constitution, and it does so unanimously. That is the most emphatic way in which the court can pronounce. And it is, I believe, a decision of 7 of the judges, and a unanimous decision declaring what the constitutional position is. I think we have an opportunity now to put this matter to rest and continue with the work of our Parliament and the work of the ordering of our state.
Sure. Now, what did the Supreme Court say about a speaker and how deputy speakers and how they can or cannot form quorum and how they can or cannot vote? What did the Supreme Court not say in this judgment? And will the heavens come down because of this decision? The principle of law is that justice must be done regardless of the consequences. What do we face? Kweku Asari, you know him popularly as Kweku Azar. And also joining us will be H. Kwesi Prempeh, Professor Henry Kwesi Prempeh with the CDD. Also, Professor Kweku Asari is also with the CDD. He's a D&D fellow. He's also an attorney in the United States of America. And he's a KPMG a guy who does a lot of work and has gone to the Supreme Court to fight on a number of constitutional issues that have held shape. I know the time where you are in the US is too early to be rising to a show like this.
Thank you so much, Samson, for having me.
Right. So let me begin with you. And I've read your piece, and you are completely against this judgment on all fronts. See if you can justify them. But this is good, that when we have difficulties, we have a place to go for a resolution like this, correct?
Yes, absolutely. It's a good thing. Not only a good thing that we can go to a place to resolve it, the judiciary accountable.
Right. Now, let's begin with your write-up, which you titled Matters Arising Out of the Abdullahi Court. That's the... You say the presiding members can wear two hats, and you have a problem with the decision of the court in that regard. Now, let's look at fought with the Attorney General in the Supreme Court. So the court had to deal with the arguments of these two parties. And you believe that the Speaker or Parliament ought to have been given an opportunity to be part of this process. How does that negate anything that has happened?
Good question, Samson. A procedural defect, such as you have described, will render the proceedings nugatory. Procedure, we will call Parliament an indispensable party. An indispensable party is one that is needed to allow a judgment to be issued on the case. Now, before doing that, let me also make a couple of observations about the opinion, and then we can do that. First, I like it very much that the opinion was timely, it was expeditious, and I hope in the future this can be applied to other cases. I must also say that rating, and that is good, because if you remember, one of the concerns that I had at the beginning of the year when you invited me was that some of these judgments tend to be too technical, and if we continue to do that, we isolate the other individuals who are not lawyers. I really commend Justice Kulendi for writing so clearly, for laying down the issues so precisely, and for the clarity with which.
So to the first question I asked you, you said that, and you have repeated right away, that there would be some question about the validity of the decision because of the absence of Parliament in the court as being a party. How so?
Samson, it's almost like me suing you that your house belongs to me, but then you are not a party to that suit. And so I go sue somebody who has no yes, the house does not belong to Samson. It's unheard of. It is a procedural defect that, as I said, render nugatory the total proceedings. But that is not the biggest problem in the judgment.
I know. I know. I want let's take it one by one, step by step.
Okay.
By what rule of that the absence of Parliament in the process renders the judgment nugatory?
By a review. You know that, of course, the Supreme Court is the apex court, and its judgment is subject to only a review. But that would be one of the arguments that can be proffered on review.
So I'm asking because I am not familiar with the principle and the basis of law for it. It's not present. The process is rendered nugatory. More particularly on a matter that turns on constitutional interpretation.
Well, yeah, I mean, if you read the civil procedure order, I think it's order 4.3, it talks about joinder of parties.
That's right.
It's just a common law. Parliament, in this case, Parliament's internal rules, Parliament standing orders. Then, at a minimum, you must hear from Parliament. More so when Parliament is a coordinate branch of government. To completely ignore Parliament's views and insights and to go about to issue an opinion which says, Parliament, this budget that you approved is constitutional or unconstitutional, as the case may be, or Parliament, that's just not the way.
In a constitutional litigation, the Attorney General, the Attorney General is the one that is known by law, recognized by law, to represent the state. Is that not correct?
It depends on whether the interest of the Attorney General is adversarial to the instituted in, I can't remember the case, but it was a judgment written by Amegache or so, or the case itself was Amegache, where it was explicitly, no, I think I take that back. It was Atububa who wrote the judgment. It was explicitly delineated that in some instances, the interest of the Attorney General may be adversarial to the state party. And in that case, that state party must be made as very well represent the interest of Parliament. Another instance where that could happen was if, as an example, the president was to say he's dismissed the Speaker of Parliament or the Chief Justice or some other state official or constitutional official. Well, the Attorney General works for the president, and it wouldn't make much for you to say that in that case, the Attorney General also represents both the president who is dismissing somebody.
The same civil procedure you refer to allows for decisions that affect to be subject to the decision and to compliance. Now, in this particular case, who did you want to be joined, and how did you expect the Parliament to be part of it? Is it the Speaker, qua Speaker, private, capacity? If it is the office of the Speaker you are talking about, you know that the office of the Speaker, if it includes the deputies, then there is a disagreement. So how could Parliament be joined? It's divided over the issue.
Well, because Parliament is a body, and that body can have representation. The representation will not be for the Speaker or for the Deputy Speaker or for any individual member of Parliament. It will be for Parliament. The Speaker can give input to the Council. The Parliament should consider having its own attorney.
And how was this going to happen? And how was this going to happen since the Parliament itself is divided over the matter?
That's what I'm saying. It's a body, and that body has representation. So it is not necessary for every person within that body to agree on a matter.
Must go with one instruction. They are going either to defend you or not to defend you. But you have a Parliament that is divided on this matter. How can, and Professor H. Kwesi Prempeh should join us because he also has this same problem on the judgment. Why Parliament was not joined?
Samson, I think you are really making a simple issue very complicated because Parliament itself has its standing orders. And what is being contested, the Council cannot take that position that Parliament is committed to the standing orders. And if the standing orders are to be revoked at all, then it must be revoked by Parliament, not by some edict of a court. That would be the function of the Council. It doesn't. The Council doesn't have to take instructions from the Speaker or Deputy Speakers and all that fighting. No, it's a simple matter. It is that standing order that is being challenged, and it is that challenge that the Council will defend.
Did the case actually turn on the standing orders, or it turned on Articles 102 and 104? Which have implications for the standing orders in reference?
The case conflicts with Article 102 and 104.1. So you cannot throw away the standing orders and decide the case. But that's what the case is. Parliament has a standing order, and it is being in the Constitution.
In the reliefs that were sought, in the 8 reliefs, Do you find any of the reliefs that turn on the standing order? There's no reference to the standing order, is there?
Well, if there is no reference to Article 102 and 104.1, it's a strange one indeed, because that's the principal holding of the case. That's what we are talking about. The court strikes down the standing order, and I'm not sure why it is so difficult for you to understand that or see that.
Okay, so Prof, I've got to do this job. So it's the how is it a strange thing when the Supreme Court is empowered by law that if it is determining any matter and such a matter of the standing order appears to be implicitly affected, it can pronounce on it. The law and the Constitution gives it power to declare what is found not to pass muster as null and void. How is that strange?
The strangeness referred to your question that the relief sought had nothing to do with the standing orders. And I am saying the principal holding itself is at variance with the relief sought. And that's why I'm saying it would be strange for the principal holding to be one that does not flow from the relief sought.
Right. And the parties that went to the issues that were to be determined before the court. So there was a joint memorandum. So these were the issues to be determined. One, whether or not upon a true and proper interpretation of Articles 102 and 104.1 of the Constitution, a defense of the Speaker cannot be counted as part of the members present before a decision is made. 2, whether or not upon a true and proper interpretation of Articles 102 and 104.1 of the Constitution, a deputy speaker or any other member of Parliament in making of a decision by Parliament. So you see, 102, 104.1, there's no mention of the standing orders. And then the final one, whether or not the decision taken on the 30th of November, excluding the person presiding, were not present in Parliament before the decision was made. This is what the parties agreed were the issues. But do you agree that it is inescapable that you cannot deal with 102, 104.1 without impeaching the standing order in question?
Well, I mean, when read the two again. The two is basically saying the deputy speaker not being able to vote. That is what the standing order in question is. That is Order 1093. Merely because they have reduced Order 1093 to words, it does not mean that the standing orders have disappeared. It's Order 1093, consistent with Articles 102 and 104.1. That's what the second issue is all about. And something, if I may say something about that number 2, I know you want to go through this methodically, but
right.
But it's important that I say what I want to say on this issue 2, if you will permit me.
Please go ahead.
I was quite astonished by the approach used to resolve issue 2. I found it to be inexcusably ahistorical. A constitution, by just looking at the 4 walls of the Constitution. Our Constitution was built on several constitutions. There were discussions and deliberations by a consultative assembly. There was a report of the committee of experts. And none of you are surprised by that. Now, Samson, the office of the deputy speaker is not a new thing. If you go back to the 1957 Constitution, there was a speaker who was a member of the National Assembly. In 1969, we had a speaker, but that speaker, because of experience, was made a non-member of parliament. And then he was also assisted by one deputy speaker. In 1979, because of the experiences of 1969, the non-MP speaker was retained, but this time it was decided that he would be assisted by two deputy speakers, one not from both 1992 Constitution, also retained. So when you do that evolution, you can learn a whole lot of things. So for instance, let's go back to in Article 40, in Article 40, 2A, it provides that the speaker shall have neither an original nor a casting vote. The speaker, okay? Remember, that speaker was a member of parliament. That speaker was a member of the National Assembly, nor a casting vote. But more important, Article 42B of the 1957 Constitution provided that any person, including the deputy speaker, shall, when presiding in the casting vote. So this was the 1957 Constitution. It specifically had a voice on whether or not the deputy speaker has an original or a casting vote, and it also told us that the MP learned some lessons. So we went to 1969. In the 1969 Constitution, at Article 82(1), it also provides that the speaker shall have neither an original nor a casting vote. And this is important because the speaker at this time was not a member of parliament. The speaker at this time was not a member of parliament. Speaker who is not a member of parliament, it is directed to somebody who is a member of parliament who performs the function of the speaker. So in 1969, you will notice that the Article 42B on the deputy speaker having an original. This drop was not some accident. It was constitutional framers looking at our history, looking at the 1957 Constitution, and learning from that and deciding that this notion that a deputy speaker or a person presiding will retain an original vote was obnoxious, and so let's drop it. Basically also has the speaker shall have neither an original nor a casting vote, and there's no reference to a deputy speaker. And finally, we have the 1992 Constitution, which basically copies from the 1979 Constitution and explicitly rejects the language of the analysis, is what I want to see when the court is making a determination as to whether or not a standing order that has been in existence for 30 years and which was copied from 1979 and 1969 is constitutional or not.
Yeah, so
when you look at that history, we learn a couple of things. One, the notion that a member of the assembly could lose his original vote is not an alien concept in our parliamentary history, as we saw in 1957. Two, the Constitution tends to be this is the model that was used in 1957. Third, the provision that allows a non-speaker to retain his original vote was not just conveniently omitted or not or forgotten.
Right. Okay. So Prof. Yes. Yes.
In 1969.
Prof. So
when you put all that together, what you learn is that our constitution, when it comes to devolution, from when the speaker was a member of parliament who did not have a vote, original or casting, to when the deputy speaker or presiding member had a vote, to the current situation where both anyone acting as a speaker, the speaker substantively, and a speaker pro tempore has no casting vote.
Right. Evolution. So if in 1957, the Constitution was specific in saying that any other person, including the deputy speaker, shall, when presiding in the assembly, have an original vote. The absence of this specificity in the subsequent constitutions.
That's what I explained, that it has been consciously dropped.
Consciously dropped?
Yes. I mean, it was there in 1957 when people were writing the 1969, 1979, and 1992 constitution. They had an relating.
The court takes decisions using principles of law. And you clearly would have read the judge or the court say, make reference to the expressio juris exclusio ulterior. The expression of one thing implies the exclusion of another.
Well, I mean, apply that rule in this case when the particular clause dealing with the deputy speaker has been dropped. Well, what does that rule tell? Set it in the Constitution. Because if the framers wanted to insert it in the Constitution, they had a template. It was right there in 1957. They could simply have copied Article 42B from the 1957 Constitution.
So hold on briefly. We'll return to this substantive issue, but let me bring in Professor H. Kwesi Prempeh. Thank you very much, Prof, for also joining us. Prof, I started Professor Kweku Asare on his concern about the absence of Parliament in the suit, and actually proceeds to pronounce that can't find, as it were, statutory or judicial decision to support that. But he makes a case. Now, you also express concern about that. And you say that as the matter involved or implicated directly setting rules of the House and ruling of the Speaker, I was expecting to see more than just a private plaintiff and the Attorney General as the parties represented in this case. Specifically, I had expected to see separate representations of the Speaker in this case. Anyway, we shall save that discussion for another day. The plaintiff takes a position that aligns with the position of the minority in Parliament. The Attorney General goes to do his job by virtue of Article 88 of the Constitution, Parliament to be doing in the case.
Thank you, Samson, and thank you for setting up this discussion with my good pal, Kweku Asare. We are not usually in court on opposite sides. So it's good to be in this court of public opinion, representing different sides of the matter. But I think Kweku does in fact raise a germane point on the procedural issue about the parties in the matter. Thompson, you have to put this in the context of our adversarial system of justice. We operate an adversarial system of justice, which means that in a matter before a court, the court relies on the advocacy of the two sides to tease out the issues before the court so that the court would get a full measure of the issues, the arguments, and the like, right? And we make sure we try to zealously argue the point. So the private plaintiff here is just like you and I, just like you, me, Kweku, any other citizen of Ghana. It's an Article 2 plaintiff. They are a nominal plaintiff. It doesn't mean that they necessarily have a special or a special interest in the matter, or an interest in the matter that is larger than the interest of you, me, and Peku. So they are a nominal plaintiff. The real party in interest, who is not before the court, is really someone with a more substantial interest in the outcome of the case, somebody who is probably the custodian of the rules of the House, which is the Speaker. That person's proceedings, right, the custodian of those rules, it is that person or that party whose rules, whose actions are the court to have the most zealous advocacy before it for the purposes of our adversarial judicial system. You have to find that plaintiff or that party who is not before the court, but who is the real party in interest in this case. Now, I have a problem, so issue. Even though they may not be the most zealous advocates of the points that they are trying to push. And yet, because we will all be affected by the outcome of an Article 2 case, because it's a constitutional case, the court must make some effort in Article 2 cases to invite more than just the private plaintiff that's before the court. So that's my number one. The second point is that the Attorney General for government, and in certain matters involving other or independent branches of government or agencies of state, I think that it is not appropriate to let the Attorney General be the only party that is joined or the only defendant in the matter, right? So, for example, we have done that with the EC. I recall that I think in the 1990s, I think it was Attorney General Robert Samoa and won. I think that is actually the appropriate model, that certain agencies of state are so independent or are expected to be so independent of the executive or of government that it is a bit unseemly to have the Attorney General representing them in matters where their interests actually may well clash with that of the Attorney General.
So, Prof, my question is, in this circumstance,
sure.
That position, what is wrong? What else would Parliament say?
Well, Parliament would have probably a take on the matter that is quite different from the perspectives that would be shared by the plaintiff and the Attorney General. For example, some of the points that Peku has raised in his intervention in this matter are not necessarily matters that were canvassed by either side of the case, right? So, if you allow the Speaker to submit, to make a submission, I mean, the court can do this by, you can even invite it as an amicus. I do think that in these matters, where there are third-party interests, and those third-party interests are real, not just nominal, that the court must find a way to join those parties or invite them to make a submission in the case so that the court has a full measure of...
It's not a practical difficulty. How is Parliament going to be part of a process that it is divided about?
It doesn't matter. I mean, you can have, if those persons who are in Parliament, for example, if you invite amicus, it could go on either side. If you invite, they can submit their brief that take another point.
Okay.
So it doesn't really matter. I think that we are inclined to see legal disputes only in a binary fashion, that there is only two sides. There could be 3 or 4 sides, right? For me, what is important is that in an adversarial system of justice, the lawyers or the parties that are before you, you must make sure that they are the ones most suitable to possible arguments, all of them, and then you make a decision based on...
The law allows any party that feels affected. The law allows any party that feels affected by an ongoing matter to apply to join.
Absolutely. In fact, I have raised this question even before this judgment came out. When I saw the case, and I thought, well, where is Parliament in this? Where is the Speaker? I actually expected that the Parliament or the Speaker, at the very least, will join the matter.
What that tells me, Prof, is that and this to the both of you. What that tells me is that the Parliament felt that the two sides of the coin, was represented in courts. The minority side, side by the plaintiff, and the majority side by the Attorney General. And so they didn't feel the need to do anything.
I disagree with this is where I have to disagree with the conclusion that Professor Asare draws. It does, because in fact there was that opportunity. There was that opportunity for the Speaker or any other party in the House to align with one or the other side, or to actually take a separate view and join this matter, apply to join this matter. And to the extent that they basically felt that their point of view was adequately represented, albeit erroneously, by one or the other side, I do not think that, that
this decision represents. You say that this decision is faithful to the text and structure of the Constitution. You say it is faithful to the text and structure of the Constitution. But before that, the little bit I want to ask here is that Prof seems to have the view, Professor Azar seems to have the view that on a review, the Parliament as a party could be a basis for the review. Do you see that that is possible? The rules of courts, CI 16, by the Supreme Court says that a review may be, the court may review, there's an exceptional circumstance which has resulted in miscarriage of justice. There must be an exceptional circumstance, and it must have resulted in a miscarriage of justice. Then two, that there's a discovery of new and important matter or evidence which after the exercise of due diligence was not decision was given. Do you think this issue can form part of the grounds for a review of this matter?
I do not think so. I think what those two grounds tell me is essentially that it must be something not merely procedural but substantive. I mean, it would be one of those instances. I think that what these two grounds tell us is that if there was, for example, it was a matter of law, right? The first ground is telling me if there is a matter of law that actually evaded the court's notice, as well as evaded almost the notice of both sides, plaintiff and defendant, petitioner and respondent, even by the exercise of due diligence, they couldn't actually have found it. And yet they found that actually it turns out there is a matter that is right on point, but we didn't pay attention to it. And that we should actually, if we had taken it into account, it would have changed the outcome. Then we will take a look at it.
Okay.
The second one is telling me if it's, for example, a matter of fact, these are evidentiary issues in a trial, and then, basically because the Supreme Court sits not only as a court of law, because its jurisdiction in constitutional matters is original, it's also a trial court, right, in that context. So maybe in a particular case, certain facts were not available to the court and to neither of the parties. By the best exercise of due diligence, they couldn't have found it, but after the fact, they have now found it. Then they bring it to the court's attention and say, oh, but if this fact or piece of evidence was before you, then it may well have changed your mind. Please take a look at it.
Okay.
Those are the circumstances I'm thinking.
Right.
Where those two grounds are talking about, not the matter of I thought that my perspective on this case would be adequately represented by the two parties before you. Unfortunately, they were not. Now I think I must come in and show you why there's a third view or there's a fourth point of view you didn't see. And I don't think that is what this is.
Okay, thank you. So now let's go to why you say this is fidelity to the structure, the text and structure of the Constitution. And it must be said also that there is a line of cases that the Supreme Court has said, and I remember people like yourself have been disappointed at the court, including Professor Kwekwa Azar, have been disappointed at the court that it does not allow the amicus, like friends of the court, people to file, to join and say what they want to say. In fact, it has said with emphasis in Abu Ramadan versus the Electoral Commission and a few other cases that none other than the parties to the suit are allowed to contest the suit. So it is possible that if Parliament attempted to join, even though the rule says you can apply to join, they may have been refused. Yes, Prof, let's go to your substantive issue.
No.
Yes.
Well, but I want to make a comment on that. I think if the court takes that position, then I think if the court has taken that position, I think the court needs to revisit it, because an Article 2 case, specifically an Article 2 case plaintiff, is just like any one of us. Like I said, the Article 2 says any citizen, right? Now, the implications of an Article 2 case, however, go beyond that citizen who brought the suit. It affects all of us equally, and sometimes unequally, actually. Some people may be affected even more by the outcome of an Article 2 case than the plaintiff who brought the matter.
Okay, Prof, let's proceed to your summary and why you say the judgment is faithful to the text and structure of the Constitution.
Right. On the substance, I think it is important for us to understand what it is that a court is invited to do when we present it with a constitutional case. I don't know if this is the effect of the way we have looked at Riakoto historically and even within the academy and the like, but I get the sense that some people have gotten this idea that the Supreme Court is so supreme that it can do constitutional interpretation without fidelity to the text. That sometimes it can put aside what the text says and go on a detour. Sometimes they call it the positive interpretation, even when the text is fairly reasonably clear and can be used with other tools or canons of interpretation to arrive at the result. Sometimes we go into these detours to find meanings that are outside of the text that sometimes even conflict with the text.
The court itself says it cannot do that.
When the court is invited to interpret and enforce a constitutional provision or a set of constitutional provisions, it is not an invitation to rewrite the Constitution. It is not an invitation to set aside the text. It is an invitation to begin with the text. The Constitution is a text for a good reason. You begin with the text. Sometimes, in very rare cases, you begin with the text and nothing and end with the text because it's so clear. If, for example, somebody brings a case and says, I am 28 years, I want to contest for the presidency, and I bring a constitutional case, fairly easy to settle that on the explicit text because the Constitution sets a minimum wage for a person to be able to contest the presidency, right? So some of them are very easy. You can dispose of it on the very plain, language of the text. Sometimes, however, the text is not that explicit, right? So then you begin with the text and then employ other legitimate tools of constitutional interpretation, including some canons of interpretation and other things, including looking at the context, including, looking at the purpose, the policy behind the provision, including, if need be, taking a look at the historical evolution of that particular provision. And then all of these other aids, the idea is for them to help you tease out the meaning of the text that is otherwise not so clear. So I say that in this particular instance, and I have always bemoaned these forays into extraneous. Sometimes the text is so clear, and then you see a judgment that says, we can't stick with the text. That is judicial activism of the kind that I think we should not be encouraging. So I find this, and I'm happy that Peku admits that it is clear. This is a very succinct, clear opinion. Stylistically speaking, it sets out the matters. However, we may come out on the outcome. It's very clear, readable, plain English. We like it, right?
Well, he disagrees. He disagrees completely, completely with the substance. Even you,
yes,
even you say This is correct, yet it's messy.
Of course, it is messy because it is messy because of the political context in which we are. And I have heard it said that because this matter involved political matters, that it was not a suitable matter for judicial resolution. I think that misunderstands or mistakes what the political question doctrine is. We have three branches of government, formally speaking. We have the judiciary, and then we have the executive, and we have the legislature. Of the three, the last two are political branches, which is that they are populated by people we elect in a political process or we appoint through a political process, and they make political decisions, which means that in making decisions, they make judgment calls, they make policy judgments, they make political preferences in arriving at a decision. The reason for the political question doctrine is this, that if you go to a court, which we want to believe is unlike the other two because it's a legal institution where matters must be framed in a particular way for the court to take cognizance of them. If you go to a court and you say, for example, I do not like the fact that the president has ordered the deployment of troops to go and support ECOMOG in Gambia. The court says, well, this is not a legal question. This does not present a justiciable legal question. This is a decision based on political judgments, based on information, based on intelligence and other things that are not ordinarily available to a court and that the court can really not do much about. So in that matter, the court will say it's a political question, we will not touch it. Or if you went to a court and said, look, this minister was vetted by Parliament, I think this person is unqualified, he just it's not fit for purpose, so we shouldn't have approved him. You take it to court, the court says, well, that political judgment about the person's qualification is something that is given to Parliament and its appointments committee and these processes. We cannot second guess them. So again, that's a political question. However, if you went and said, look, this person that you approved doesn't meet the constitutionally stipulated minimum qualifications, which means that, for example, he must be qualified to be a member of Parliament, and you show that in the matters that are listed under the qualification for MPs, this person actually fails on the face of it, just doesn't qualify at all. You have evidence, you have the facts to support you. The court will take cognizance of that particular issue and say, oh, okay, because the Constitution regulates the qualifications of ministers and ties them to the qualifications of MPs, even though you are challenging a decision that came out of that process, you are standing on a constitutional disqualification. So in that matter, it is not just a political question. We will take judicial notice of, we will take judicial cognizance of the case and determine it. So the political question doctrine only applies in those cases where you are saying that a matter that has been brought before the court is not a proper matter for judicial determination because other branches of government are best suited to resolve those matters because it involves matters that lie exclusively within their domain, their policy discretion, their political judgment, and we leave it to them to do it, right? So, for example, I'll give you an instance. In 2014, there was an anti-LGBT bill that was brought before, that was passed by Parliament in Uganda. It was challenged after it had been passed into law. It was challenged not on the substance, but on the fact that there was no quorum in the Parliament that passed it at the time that it was passed. There was no quorum. And evidence was adduced in the matter to show that, indeed, there was no quorum. The Constitution stipulates a quorum for parliamentary business, and the Hansard and other things that were adduced in evidence showed clearly there was no quorum. And the court said on the basis of that, it is unconstitutional. Would you then say that, oh, because this matter involves something in Parliament, the court, and Parliament is a master of its own rules, the court cannot? No, that is not what the political question doctrine says. The political question doctrine only ties the court's hand when the matter is purely left to the political policy discretion of the political branches, and they have made a certain choice that you think you don't agree with and you want to change it into a political matter, right? So I think we must explain clearly what this is.
All right.
There is also a misconception that because this thing involves political consequences and it might go one way or the other, there might be a partisan aspect to it, the court must stay its hand. A lot of constitutional cases are actually cases that have huge political ramifications, huge partisan ramifications. Take, for example, the 31st December case. Nobody doubts. And even not just that case, a number of the cases brought before the Supreme Court in the period when the NPP was absent from Parliament from 1993 to 1996